Good evening, everyone, and welcome. My name is Joanne Pearson with the Center for Independent Living of Northwest Florida, and I am going to be your tech host today. So I want to take a moment and go over some housekeeping details for this presentation. Once we get to the Q&A, question and answer period, which will be towards the end of the presentation, please feel free to type your answer or your questions into the Q&A box, which is located on your toolbar. Depending on your setup, it may be above the screen or below the screen, but it's labeled Q&A. We want you to type the questions into that area so that they're easy to field to our speaker. So thank you very much for doing that. The chat is available for you to talk among yourselves and introduce yourselves to each other and share information about if you have an organization, so on and so forth. So for right now, I'm going to let Carolyn Growie, our wonderful executive director here at CIL of Northwest Florida, have the floor. Carolyn.
Thank you so much, Joanne. I greatly appreciate your turning it over to me. It's very nice to be able to see everybody, and I'll have Joanne be able to please bring up our slide about the center. Joanne, it went back. Okay, there we go. So good evening again, everybody. I'm Carolyn Growie, and I'm the Executive Director of the Center for Independent Living of Northwest Florida. And we've been in business here for about 41 years. We work with and on behalf of people with disabilities to promote, educate, facilitate, assist, and advocate with and on behalf of persons with disabilities in partnership with their communities, so individuals can achieve their own goals for independence. When we say that, we are looking at the ways in which individuals make their own choices, and that we work with somebody to achieve what they would like to. And tonight we're going to learn a bit about what happens when some of us need different supports at different times and how that can be provided a bit. Our mission here at the Center for Independent Living is to serve all individuals with disabilities, to provide opportunities in Escambia, Santa Rosa, Okaloosa, and Walton counties. We are also regional consultants for the ADA, and we serve all 5 of the main title actions of the center's piece for the core services that we provide. We do individual and systems advocacy, which we're going to obviously be learning today about how somebody can have an individual advocate that would be different than being just themselves, but being able to have somebody who's only in their court for them, for their well-being. We also provide peer mentorship and peer counseling, where we are able to talk with individuals or have individuals be able to participate in support groups. We additionally, of course, have independent living skills, and we do information and referral. So in fact, if you were to call us today and say that you needed a guardianship advocacy assistance, then our speaker today would be somebody that we could refer you to. As well, we provide services through a few of our grant programs that we have, and those include our FTRI program, which is for individuals who may have some area of difficulty hearing on the telephone. And with the Florida Telecommunications Relay Incorporated, we're able to provide phones through the state of Florida to individuals in our community. We also have a program called FAST, which is the Florida Alliance for Assistive Services and Technologies. And through that program, individuals can try before they buy to see if there's a particular type of equipment that might be useful to them. And it gives them an opportunity and a way to see if things can allow for greater capacity to achieve their goals independently. And we also look at different types of equipment or pieces that may be able to be repaired or loaned out that are ways that, again, would give somebody some more independence. When we do all of those things, that we see that allows us to be able to also assist folks through social and recreational activities, other types of support groups. We provide community education and training, which, for example, we're going to be doing tonight. And we're able to make sure that individuals have those opportunities to make transitions in their lives that might be between going from high school onto a college program, or it might be from high school onto independence and working. It might be a trade school. At different levels, people are able to participate and have a say in what their future might look like. We also do transition services and diversion services that allow individuals that, as information changes for their disability, to avoid being institutionalized. Again, people work on their goals to live their life at the level of independence that makes their life best for them. So today we are going to learn more about what is guardian advocacy for adults with developmental disabilities. We have the pleasure, and we're so excited to have her here tonight, to have Lauren Merritt join us today, and she is going to present on Florida's guardianship advocacy process and help us to learn how individuals with disabilities can qualify for this program and what it takes to be part of it. We're very excited to have her here, and she provides legal services in both guardian advocacy and also in probate court. And so with that, let me introduce to you Lauren Merritt, and we'll get to learn from her tonight. Thank you so much for being here.
Thank you, Carolyn, and thank you, Joanne. My name is Lauren Merritt, and as has already been mentioned, I practice probate and guardianship law here in Pensacola, Florida. And thank you to everyone for joining us this evening. I know everyone has busy schedules, so I appreciate you taking some time out of your day to learn some information about guardian advocacy in the state of Florida. And I'm just very grateful to be part of CIL's mission this evening. It is a wonderful organization, so thank you for the opportunity to speak. So first, we're going to talk about what is guardian advocacy, and if we could switch to the next slide, please. So guardian advocacy is a special type of guardianship in Florida that the legislature designed specifically for individuals that have developmental disabilities. And so it is designed for persons with disabilities who lack the decision-making ability to do some, but not all of the tasks necessary to care for their person and their property. And so when an individual has developmental disabilities that render them unable to care for their person or their property, the court can appoint a guardian advocate to step in and fulfill all of the things that they've probably been doing already up until the point when that person turned 18. But when someone turns 18 in the state of Florida, whether they have a disability or not, the law recognizes that person as a legal adult. And so the guardian advocate is necessary to be appointed by the court so that the caregiver or the parent can continue assisting the person with the disability in making medical decisions, financial decisions, educational decisions, legal decisions, decisions about personal services, all of the things that they've had help with up until the point that they turned 18. The guardian advocate can step in and continue providing those services after the person reaches the age of 18. And our next slide talks about who is developmentally disabled, and that is defined by statute. And I have a list here on my slide that outlines which disabilities qualify for the guardian advocacy. So an intellectual disability with an IQ of less than 70, someone with cerebral palsy, autism, spina bifida, Down syndrome, Phelan-McDermid syndrome, or Prader-Willi syndrome. Now, the developmental disability has to manifest before the age of 18, and it has to present a substantial handicap that is expected to continue indefinitely. Now, let's talk about autism as an example, because sometimes a person who has autism may have the autism diagnosis, but they may be very high on the spectrum, and they may be perfectly capable of caring for their person and their property. They may not need a guardian advocate. They may not qualify for a guardian advocate. So just because the person has one of the disabilities defined in the statute does not in and of itself mean that they will qualify for the guardian advocacy. The judge is going to want to make sure that that person actually requires the services. If they are capable of living independently, that's always going to be the first choice. Guardian advocacy is only if it is absolutely necessary, and most importantly, if it's in the person's best interest. So that's who is developmentally disabled. And if we could go to the next slide, I'd like to talk for a minute, how is guardian advocacy different from a traditional guardianship? So first, I'm going to say how they're not different. They are not different because at the end of the day, a guardian advocate and a traditional guardian has all of the same powers. Everyone is going to acquire the same authority. The difference is the process that it takes to get there. And the benefit of the guardian advocacy is it's an abbreviated process that allows us to skip some of the painful steps in the traditional guardianship, which the primary one is in a traditional guardianship. And when I say traditional, let me give you an example. Let's say an elderly adult who is been diagnosed with dementia and is starting to become incapacitated for that reason. In that type of guardianship, the court has to appoint an examining committee that has to have at least 3 members on it, one of which has to be a physician or a psychiatrist. And they have to examine the ward and submit reports. And there's a hearing just for the purpose of determining whether or not that person is incapacitated. In the guardian advocacy, we get to skip that step. And instead of having the person go through the steps of the examining committee, the court is permitted to accept medical records and educational records that are already in existence. And the court is permitted to rely on those records to determine the incapacity. So I usually, when I'm working with clients, in a perfect world, I like to have at least 1 medical record and at least 1 educational record. For the educational record, most commonly, it's an IEP, individual education plan. And then for the medical records, it's usually just from the primary care physician. And I just need to see somewhere on there that diagnosis spelled out. And if it's even better if the report will state, that this has been present since birth or however long it's been since the diagnosis and whether it's expected to continue indefinitely. So that's the difference. And then on our next slide, we're going to talk about what are the powers of a guardian advocate. So I've already kind of hit the broad categories: financial, educational, medical, and legal. And so these next 2 slides are going to spell them out a little bit more specifically, what the powers of a guardian advocate are once they have been granted letters of guardianship by the court. So a guardian advocate on behalf of a disabled person can enter into legal contracts and manage delegable legal rights, sue and defend lawsuits. Hopefully nobody ever gets tied up in a lawsuit, but if someone were to be in a car accident or heaven forbid slip and fall in a store somewhere, or any number of ways that they were in a position where they were injured and needed to be represented in a lawsuit, the guardian advocate can help with that. Number 3 is a big one, and that is applying for and managing government benefits. So Social Security is almost always something I encourage my clients to apply for once they have been appointed as the guardian advocate. And a lot of times they say, oh, well, we applied before he or she was 17 and we were denied. But I do always encourage them, once they turn 18 and you're appointed guardian advocate, submit a new application, because my understanding is that although income may still count, it may count differently. And someone who did not qualify as a minor may qualify once they're 18. So guardian advocate will be able to assist with that application. Guardian advocates can also manage property or make gifts of property. Most of the time, most of the families that I'm working with, the person with a disability typically doesn't have a lot of property beyond personal belongings. So I don't usually have families that need that one, but it is in there if it's needed. And if we could go to the next slide, please. All right, number 5, determine residence. That may seem inconsequential, but when we have someone who is kind of on the borderline of do they need a guardian advocate or they don't, sometimes I've worked with families where it's someone who's easily influenced, and there may be another adult that they've met that wants them to go and live here and pay all of the rent or move away from home where mom and dad are really not able to make sure that their best interests are being protected and that their health and safety is being protected. So being able to determine residence gives the guardian advocate the authority to make sure that the person with a disability is in the best residential setting that's going to protect their best interests. Medical would be number 6. So being able to go to doctor's appointments and request medical records if needed. The guardian advocates can do that. And I've worked with a lot of families who have been seeing the same doctor since their child was young. And even though they're 18, the doctors will still kind of sometimes turn a blind eye and still allow them to participate in the medical portion of things, even when maybe it's kind of in the gray area. But I will tell you that I have also worked with families where we were right on the edge of getting the guardian advocacy approved before the child turned 18. The orders were not signed in time. And this particular person had a very serious medical condition. They were seeing an out-of-town provider. And on the child's 18th birthday, the provider shut the family out of the medical portal for that person, and it really presented a problem. Thankfully, we were able to work around it by showing that the guardian advocacy was in progress and that person was able to get all the medical care that she needed. But I use that as a worst case scenario example of problems that I have seen folks run into with doctors. Number 7 is for educational decisions. So if someone is enrolled in a program beyond, the elementary education, doing any vocational services, this would allow the guardian advocate to act on their behalf in getting them registered and enrolled in any personal care services or educational services that they want to receive. And number 8 is kind of just a catch-all. The guardian advocate has the power to make all decisions on what types of social environment that the disabled person is going to be exposed to. All right, and if we can go to the next slide, we can start discussing who can serve as a guardian advocate. And generally, any Florida resident who is at least 18 years old and of sound mind can serve. So if the person is a Florida resident, there's no requirement that the guardian advocate be a relative of the person with a disability. But if the person is a non-Florida resident, you do have to be directly related or be a legally adoptive parent. So you may be thinking, well, if we're dealing with a Florida guardian advocacy, the disabled person's in Florida, so why would a non-resident be appointed as a guardian advocate in the first place? And the reason for that is anytime I've asked to have a non-resident appointed, there has also been a Florida resident that has been appointed. That's going to be the person that's the primary caregiver, but maybe there's an aunt or a grandparent who lives out of town who visits often, or who may be the backup plan. And we're going to talk more about standby guardian advocates as a tool for backup plan, but sometimes more than one person can be named so that if the primary guardian advocate becomes unable to serve, there's already automatically somebody who's been appointed that doesn't have to jump through any more legal hoops that can serve. So that's an example of when a non-Florida resident may be appointed. And if we can go to the next slide, we'll talk about who has preference to serve. So it's always wonderful when I have so many people wanting to serve that we have to kind of look at, well, who's first in line, who has priority to serve. And so someone who is related by blood or marriage to the person with a disability always has priority. They're first in line to serve. So a parent would definitely be usually who is applying, but I've also seen grandparents, aunts and uncles, occasionally siblings are named. Next in line is someone who has a special experience, whether it's educational, professional experience that specially qualifies them, or has the capacity to manage finances involved. So if it's someone that does have a lot of assets and there's no family that's able to serve, but there's someone who's willing to serve that has a special financial background or financial degree, the court would give deference to that person. And then the last one is kind of another catch-all, just anyone who has the requirements and to meet the unique needs of the individual. So if it's someone that has a developmental disability that's going to require a lot of one-on-one care, someone who is not employed might be a good fit, and may be specially qualified to meet the unique needs of that person. So that is who has preference. Next, we're going to talk about who cannot serve. And this is a hard one sometimes, because the very first one, if you have been convicted of a felony, you are disqualified from serving. And that is very unfortunate, because it does not matter how long ago the felony happened. It doesn't matter if you've been rehabilitated. It doesn't matter if you're the only parent caring for this person. I have not found any loopholes around this. And I've spoken with colleagues who are not aware of any loopholes around this. So I have encountered this several times, parents who, were not perfect. And I've made mistakes in my past. People that I work with have made mistakes in their past, some more serious than others. So when we run into a situation where someone has a felony conviction, we try to get creative on who else can we appoint. And just because you're disqualified to be the guardian advocate does not mean that you're going to lose your parental rights. It doesn't mean that you no longer have a say in how your child or your loved one is cared for. It just means that on paper, you're not going to be the guardian advocate. And so in situations where a guardian advocate is needed, whoever is appointed would go with you and be able to assist you with that. So if we could, I think we skipped ahead one slide. If we could go back, I got a couple more things to cover on who cannot serve. And they're kind of obvious. So if you become incapacitated, or you get really, really sick and you're just not able to fulfill the duties of guardian advocate in the way that you were when the court originally appointed you, at that time you would be disqualified to serve. If you're unsuitable to perform the duties, then you're disqualified from serving. And if you've ever been judicially determined to have committed abuse, abandonment, or neglect against the child, those would probably be felonies that would be included in section 1, but that would preclude you from serving as well. And that is it for that slide. Now we can go to co-guardian advocates. So we've already talked a little bit, or at least I've alluded to co-guardian advocates, and that is more than one guardian advocate can be appointed. And depending on the court, you can get creative with this. Typically, I just have 2, and it's usually 2 parents that are serving, but I have had a situation where it was 2 parents and also an aunt, and then a second aunt with limited powers. And the court allowed that. So really, I tried to work with whatever the family's dynamic is, whatever is going to be best for that family. That's what we tried to design and set up. And so I work with parents that are divorced and have time sharing. Now, I personally only handle uncontested cases. So I have a colleague that I refer cases to if we were dealing with a situation where maybe the divorce was not amicable and there's disagreement on who should serve, but ideally there's a timeshare agreement in place, and the guardian advocates the parents can both be appointed as guardian advocates and continue to parent the person together as a not as a couple anymore, but together as parents, co-parent. And then you can also have grandparents, aunts, or uncles appointed as co-guardian advocates. Again, it just really goes to what's best for your family and what is best for the person with a disability. Who do they get along with the best? Who do they have the closest relationship with? Who do they trust? So those are all things to take into consideration when you're deciding who you're going to ask the court to appoint as the guardian advocate. And then I believe our next slide is standby guardian advocates. And a standby guardian advocate is basically a good planning tool. My disclaimer is this is not a planning tool that is meant to substitute for any estate planning that you may do with an estate planning attorney, but it is a way for you to tell the judge when you establish the guardian advocacy, judge, these are the two people, or this is the one person that's going to be appointed. We're asking you to appoint guardian advocacy now. And in the event that we are no longer able to serve in the future, this is the person that we would like you to immediately consider and know this person already has our approval. So a standby guardian advocate gets named when you ask for it, but the standby guardian advocate does not acquire any powers at that time. So it is only when the acting guardian advocate or guardian advocates are no longer able to serve, whether they've died or resigned or been removed, then the standby guardian advocate immediately assumes the duties, but within 20 days is supposed to petition the court and let the court know the judge, the guardian advocates are no longer able to serve. I've been named as standby guardian advocate, and I would now like to go through the steps that we're going to talk to a little later in the slide to have my standby status upgraded to a guardian advocate status. So when people are deciding whether to name a person as a standby guardian advocate or a co-guardian advocate, you really just have to ask yourself, do I need this person to have authority now? If it's someone that's going to help you get your loved one to doctor's appointments or needs to be on standby to attend vocational meetings or school meetings, then you may want to consider having them as a co-guardian advocate. But if you feel like you have that covered and you've got enough support in that category, then standby guardian advocate is definitely a good planning tool that I recommend. All right, next slide, please. We are going to talk about when can you ask to serve as a standby guardian advocate. So no guardian advocate needs to be appointed during a disabled person's childhood. When a person is still a minor, you are the legal guardian for that person and no guardian advocate is needed. But once the 18th birthday starts growing near is when you should start getting your ducks in a row and deciding if this is something that you would like to consider. The earliest that you can file is 6 months before the person's 18th birthday. Now, I do guardian advocacies in counties across the state of Florida, and I recently encountered one county down south that rejected my petition. I filed it 5 months before the 18th birthday, and they rejected the petition, and that particular county will only allow you to file 1 month early. So I suppose it's county specific. I think the law is pretty clear that you can file 6 months early, but I learned early on in my practice, the clerk is never wrong. But here in Escambia County, I have not had any trouble filing them early. I think getting an early start is ideal because the process can take between 3 and 6 months from the first petition to approval of the initial reports. Doesn't necessarily take that long to get the guardian advocate appointed, but you want to have them appointed before 18 if possible. So getting an early start is always a good idea. And if we could transition to the next slide, please. I am going to take us through the 10 basic steps of the guardian advocacy proceeding. And the first step on the next slide is to gather our documents for disabilities. We could skip to the next slide, please, ma'am. So step 1 is to document the disabilities. So those are getting together those reports we talked about, a medical report and an educational report, ideally. If the person is well over the age of 18 already and you're just now learning about guardian advocacy and you don't have a recent IEP, that's fine. I'm sure you have recent medical records, or if you don't, you can take a trip to the doctor and explain to the doctor. Most physicians are familiar with this type of guardianship and are glad to write a letter or a report. So that is step one. Step one is gather your documents and provide them to your lawyer. Step two is to petition the court. So the petition is the name for the document that I draft, letting the court know that we are asking to appoint a guardian advocate or co-guardian advocates. And it gets filed in the circuit court in the county where the disabled person resides. So if you live in Pensacola, we're in Escambia County. If you live in Gulf Breeze, we're in Santa Rosa County. And when the petition is filed is when we also file those documents that you gathered evidencing the disability. And if there are any next of kin who are not joining in the petition, the judge is going to require that we get consent from that person or that we notice that person. So let's go back to the example where we have divorced parents. If mom comes to my office and says, I want guardian advocacy, my next question is dad going to sign a consent? Because the judge is going to, at the very least, require that we serve dad, because dad is next of kin and has a right to have a voice in that proceeding and participate if he wishes. So those are the consents. Step three comes as a surprise to some people, and that is the person with the disability gets their very own lawyer. So we've got 2 lawyers and a judge involved in these guardian advocate proceedings. And the lawyer that is usually appointed in Escambia and Santa Rosa counties, the judge appoints that attorney. It's not someone that I choose. Their job is to represent the interests of the person with the disability. So that is just to make sure that no one is trying to take advantage of the disabled person, and also to make sure that a neutral third party believes that a guardian advocacy is appropriate. And so the court appoints that attorney, and that attorney will meet with the disabled person, and the guardian advocates are permitted to be present for that meeting. And I've been on both sides. I've been the attorney for the disabled person, and of course I've also been the attorney for the guardian advocates. Usually the guardians are present because the disability would just make it uncomfortable for the person to meet with a total stranger. So mom and dad or whoever it is that's applying is welcome to be present. And the meeting is usually brief. We usually just take that opportunity to learn a little bit about the person with the disability. What do they like to do for fun? What sorts of programs are they enrolled in? Last week, I met with someone whose cheerleading team had actually won the gold medal at state in Orlando. So it's always fun to learn about the neat stuff folks are doing. That's step 3, the attorney for the disabled person. Step 4 is the court hearing. And right now, as I'm sure comes at no surprise, all of our court hearings are by Zoom. And so I usually have the families come to my office when it's convenient. I prefer to have them here with me in person, and then the judges by Zoom, and the attorney appointed to represent the disabled person also appears by Zoom. And the court hearings are usually very brief. I would say 15 to 30 minutes. The judge will, sometimes the judge doesn't even ask me to speak. Sometimes he or she has already read the petition and feels it's very evident that a guardian advocacy is appropriate. I will tell you, the judge gives a lot of deference to what the attorney for the disabled person has to say. Sometimes the attorney will file a written report prior to the hearing. So in those cases, the judge already has a pretty good idea or very good idea of what that attorney has to say. Other times, if the written report hasn't been filed, that attorney will speak at the hearing and give his or her opinion on if he thinks guardian advocacy should be granted. And at the end of the hearing is when the judge will consider the proposed orders. Before we skip to that slide, I will say that I think that the hearings are going to be by Zoom for the foreseeable future. I think originally when we were adjusting to the technology, it was a little bit painful, but now I think the judges and the lawyers alike have both discovered it's just very convenient for scheduling and travel for everyone to keep them by Zoom. And because these hearings are not evidentiary hearings, it's not like a trial, I think that they will continue to be on Zoom. And that has been nice for me because it's enabled me to help families who are far away that I would not have otherwise been able to represent, because I probably would not drive down to South Florida for a 15-minute hearing, and it would just be cost prohibitive for the family. And surprisingly, there are not many lawyers that specialize in this area. So people have trouble finding lawyers that are close by that do guardian advocacy. So Zoom has been a blessing in disguise for us in the guardianship world, and it's really helped me help more folks. So that's my spiel on Zoom. So moving on to the next step, step 5, is a background check. Now, the statute that outlines the requirements for guardians in the state of Florida says that a guardian has to submit to a level 2 background screening in order to serve in the capacity as a guardian or guardian advocate. My experience has been that when I am working with parents and sometimes grandparents, the judges in Escambia and Santa Rosa have almost always waived that background check. It's when we start getting more distant relationships, like I had a cousin apply and the judge did not waive a background check for the cousin. So it just really, it's a case-by-case basis, but the pattern I've seen is the closer in relationship the guardian is to the person with a disability, the more likely it is that you'll get the background check waived. Now, if you don't have a felony on your record, then the background check isn't going to be a problem. It's not going to prohibit you from getting guardianship, but it is just a little bit of a headache. The steps are that you go down to the local sheriff's office or police station and get fingerprinted. You have to get a special code from the clerk of court that tells them where to send the fingerprints to, and then you have to register online with the Florida Department of Law Enforcement. There is a fee there. I think it is in the ballpark of $65-ish. It's so infrequent that I have to get these. I don't know off the top of my head. But I do want to make sure everybody's aware that is in the statute. Most of the time it is waived, much like the next slide we're going to discuss, which is a credit history check. So same statute. It says that a guardian has to submit to a credit check. Now, I get this one waived just as much, if not more. And the reason being, in most cases, the disabled person does not have any assets to be managed or mismanaged. So the reason why the credit check is even there in the first place is because the court doesn't want to appoint someone to manage somebody else's money if they've struggled to manage their own money or have had some hardships there. But that's not to say if you've had financial hardship in the past, if you are back on solid ground, that, based on my experience, is not going to prevent you from being appointed. Having let's say a bankruptcy, does not have the same effect that, say, a felony does. Felony, there's no way around it. Bankruptcy, I have had in several of my cases, and the judge just wants to know how many years ago was it. 5 or more years, I haven't seen a problem. So, and especially if there are no assets to manage, it's not going to be a problem. So chances are that one will be waived as well. All right. Step number 7, rather, if we could go to the next slide, is the letters of guardianship. Now, that is the name for the court order that the judge signs. I tell people it's the most important document in the whole guardianship. It's usually just 1 page, and it outlines who are the co-guardian advocates, or who is the guardian advocate, and what is the name of the person with the disability that they have guardianship over. So that is signed usually after the hearing. A lot of times I submit my proposed orders to the court before the hearing. And so if I'm lucky, as soon as the hearing's over, the judge signs the orders and I get the orders the same day. If I'm not lucky, the judge has a hearing immediately after mine and the orders aren't reviewed for 3 weeks. So it really just depends on how busy the court is. But that is the letters of guardianship is the document that you're going to want to make sure you have several copies of. And I always provide one plain copy to my clients and I get 3 certified copies from the clerk. And that copy on my little graphic there is certified. It has that stamp at the bottom showing that it's an official record. And so I encourage my clients to keep that in a special place, because anytime that you are dealing with a third party that needs proof that you have the right to be present for a meeting or whatever you're trying to help your loved one with, that's the document that you're going to want to show them, are the letters of guardianship. All right, next slide. Step number 8 is another requirement that's in the statute. This is one that does not have to be done before the court orders are signed, and that is guardian education. So the statute says that every guardian in the state of Florida must complete 8 hours of guardianship instruction taught by a court-approved organization. And you have to do it within 4 months of being appointed by the court as a guardian or guardian advocate. Here locally, what that looks like is an 8-hour class on a Saturday that's put on by Pensacola State College. And it is offered like once a quarter. It's not every month. The last I checked, it was only online, but that may have changed because this is another requirement that the court is permitted to waive, and often does waive, similar to the background check. If it's a parent or someone that's very closely related, that's been very involved in raising that person up until the point that the guardian advocacy is established, a lot of times the court will waive it. I have a lot of clients that say, hey, I might learn something new. I want to take the class. And so that is certainly something that you are welcome to do. I believe the cost is about $38, so it's not terribly expensive. I think that the biggest burden is just the time, because it is all day on a weekend, but you have 4 months to get it done. So you can plan ahead and get babysitters or time off work well in advance of needing to do that. And so if you do take the course, you'll get a certificate of completion, and that just needs to get filed with the court. So if you're working with, well, you will be working with a lawyer, because you have to have a lawyer to file as a guardian in Florida. So you would want to provide that to your lawyer, and the lawyer would file it with the court so that you could check that box off and move on to the next step, which would be step number 9, initial reports. So unfortunately in Florida, there are reporting requirements, and I promise you they are not as bad as they sound. And when I work with clients, I try to do as much of the work myself as I can, so that you can focus on caring for your loved one and I can focus on the paperwork. So we have 2 different phases of reports, and the first reports are called the initial reports, and they are due within 60 days of being appointed as the guardian advocate. So you have 60 days to get everything together. And really the initial reports are 2 parts. One is a report of the person, the other is a report of the property. The report of the person is going to have very basic information, like where does he or she live? What type of insurance benefits are there, if any? Who are the doctors or other providers providing services? The statute was just recently amended to add some new requirements in there. One is if there are any pre-existing orders not to resuscitate, you have to list those. But with the guardian advocacy, chances are no one's ever had capacity to sign an order not to resuscitate. So I haven't met any guardian advocate clients who have orders not to resuscitate. Some people know that as DNR. And then the other new one that they just added is you have to disclose if you are receiving any remuneration for serving as guardian. So if you are being paid to serve as the guardian, that has to be disclosed. And I think the reason why they added that in is primarily in some elderly guardianships, family members were fighting over who can be mom and dad's guardian, and they were paying themselves quite generously. And that was, that's exploiting the ward is the name of the person in that case. And so most of the clients I work with are not being paid. They are doing it out of the kindness of their hearts because they love that person. And so most of my clients, or all of my clients, have none for that one. So that's the report of the person. Report of the property is just an initial inventory of any assets. Most of the time, I just have $0, and that the only assets are nominal personal assets. And then if the person is receiving Social Security income, we do list that there. But if the guardian is also the representative payee for the Social Security, Florida statutes say that future accountings can be waived. So I have that a lot of the time where there's no money in bank accounts owned by the disabled person, but they are receiving Social Security. The guardian is the representative payee. So the law says that moving forward, and we're going to talk about annual reports next, moving forward, the annual accounting can be waived as long as the only asset is Social Security money and the guardian is the representative payee. You don't have to account for that. And thankfully so, because usually it's a nominal amount and it would just be a pain in the butt to have to account for that every single month. So I'm grateful that we have that statute, and the judges grant that. A motion to waive annual accountings grant that in every case that I have when that's the only asset. So we'll go to the last step. Step number 10 is the annual reports. And again, usually the annual accounting is waived. So most families I work with are only looking at one annual report, annual. So it's once a year. It's not once a month. And that is just a report that is a little different than the initial report, but very similar in the sense that you're updating the court on where does the disabled person reside? Have you changed residences? Has any insurance changed? What is a summary of medical care and personal services that the person received in the year prior? And then the biggest difference on the annual report from the initial report is you are required to have a physician's report that is recent. It has to be within 90 days of the reporting period. And I thought about trying to explain the reporting periods on here. I came to the conclusion it's kind of complicated. It's easier for me to work with people on a case-by-case basis. But basically, if your letters of guardianship are entered in the month of May, then your reporting period is going to be June 1st to May 31st of the following year. So that will be your reporting period. And your physician's report would need to be no more than 90 days before that. So no more than 3 months before June. So whenever I am working with families, I touch base with them months in advance of the annual reports being due to say, hey, here's a reminder, your annual report's due, and here's a copy of the physician's form. Don't forget to take it to the doctor and get it signed. So when it is time to file your annual report, we have a physician's report that we can file with it to make sure that everything is in order. And the way it works with those reports is before the reports ever get to the judge, the clerk does an audit. So the clerk has a checklist with all of the things that are required to be in the report, and they check one by one, yes, 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 yes. And once it's audited, I get a copy of the audit that tells me that I can send the proposed orders to the judge, and then it usually takes a couple weeks to get the orders signed. And I was going to say one other thing about the proposed orders. Oh, I know what I was going to say. My proposed orders just track the statute exactly. So I go in the same order as the statute, same verbiage as the statute, just to ensure that when it goes to the clerk is tracking the statute. My reports track the statute. That just ensures that we get everything filed without any problems. All right, I think that takes us to the last slide. I talked longer than I expected I would talk. Oh, I forgot about this slide. I won't keep yapping, but I do have a free guardian advocacy report on my website. It has a lot of the information that we've covered today in a prettier format, more condensed. It's 4 pages long. That's what the front of it looks like there. So you can either go to laurenmerrittlaw.com and find the report there, or you can email me and I would be glad to email a copy to you. So that, I think, takes us to our last slide.
Great. Thank you so very much, Lauren. We greatly appreciate all the information that you shared with us. And just so that our viewers who might see this after or who are listening and who may have any vision impairment, we'll just go ahead and just share how people can be in touch with you or in touch with the center, and then we'll move on to questions and answers. So again, this is Lauren Merritt from Lauren A. Merritt Esquire, and she has an office down in Villas Square area at 111, so again, 111 South Villas Street, Suite B, and it's here in Pensacola. And her office phone number is 850-741-2999. Again, 850-741-2999. And then you can email her. She said if you want to go to her website, you can, or you can email her at lauren@laurenmerrittlaw.com. And so we are certainly want to make sure that people can access Lauren's services. And then if you have other kinds of things that are related to disability, or if you, for some reason, don't remember how to reach Lauren and you need us to help refer you over there, you are welcome to contact the center at Center for Independent Living of Northwest Florida. We are still not seeing people in person except by appointment, and most of that is in our parking lot. But we have done some things where we've met at locations or places that were convenient for the parties that we're trying to meet. And that's so our office is at 3600 North Pace Boulevard here in Pensacola. Again, we cover the 4 counties. So as an example, I was recently at an advocacy matter that was out in Okaloosa County. So the person didn't come from Okaloosa to meet with us here. I went to Okaloosa and we met outside of their home there. So that's an example of what had happened, because we had other work to do that was related to Okaloosa. The phone number here at our office, which is kind of funny that our phone number is saying it's your phone number here on this form, but our phone number is 850-595-5566. Again, our phone number here at the CIL is 850-595-5566. We can take general emails at info@cilnwf.org. And when you write to that email, you're not just going to an empty pot. What happens is when things come in there, they get directed to the particular staff member, which will handle that particular matter that you're referencing or needing assistance with. And of course, you can always visit us on our website at cilnwf.org. This particular presentation will also appear on our archived websites after today. It will take a little bit of time because we try to make sure we only put up webinars that have been captioned, but we do want to make sure that you'll have that available in an opportunity to review some of the information. We did have one question which I saw popped up, which I'll just address here, Joanne, before I have you go into some other questions, which is that an individual asked if the PowerPoint will be available and could be sent to them. And so would you be okay with the PowerPoint being shared with our participants who are online, and if somebody else had requested it? Or would you like that to come through your office, Lauren? How would you like them to obtain that?
You are welcome to share with anyone and everyone that would like it.
So we will make sure that we do that for the individual who asked, and we'll make sure we offer that to all of our attendees today. I know we also had some other questions that kind of predated the discussion that we were having today. So maybe I'll start with one of those, and then we can bounce back and forth between Joanne and I giving some questions to you, Lauren. One question that I have, and as most of the community knows, is that I'm a very strong advocate myself, and not just for myself, but for the center and for the community and for individuals with disabilities. And I'm wondering if you have multiple parties who want to be the primary advocate for somebody, does the court take into account, or do you as the lawyer who's helping to represent the family to get guardian advocacy, do you have any conversation with the person with disability to help guide what maybe their first choice might be of who their primary guardian may be?
That's a great question. So, and I will say I don't do contested cases, but in a situation like this, it would be the lawyer's job ethically to advocate strongest for their client. So if they are representing mom, if let's say I was representing mom, it would be my job to do everything I could to advocate on mom being the chosen guardian. But the guardian, or I'm sorry, the attorney that is appointed to represent the person with a disability will certainly be having very intimate conversations, if possible. Sometimes if someone's nonverbal, it may be difficult to have that conversation. But the attorney representing the person with a disability, the court would really be turning to them in a case like that to say, well, who do you think is in the best interest of this person to be appointed? So if that person, the disabled person, had a preference, it would certainly be expressed, and it would be expressed by his or her own attorney, because they would have their own attorney.
Okay, great. Joanne, do you want to go ahead, or do you want me to keep going? I think because she's muted, I'll just go ahead with another one, and then we'll be able to have her jump in. What happens for the individual with disability who maybe their guardianship guardian advocate has been appointed and it's not working for them? Maybe it's the case, like as the example, where somebody's getting Social Security and then they're now not getting any of those dollars to spend on things that they would like to have actionable options with. So maybe, I don't know, whatever the amount might be, if it was $30 a month that was previously being given to somebody to have freedom to spend, and now they're not getting any of their dollars to spend themselves, or maybe they feel like they're not being housed in an adequate situation anymore, and they can't maybe make all their decisions themselves, and that's why they have the guardian advocacy. And so what would be something that the individual would need to do if they wanted to see that changed?
Sure. Well, so if we're dealing with a situation where someone's money is being managed and they feel like they should be managing it themselves, I guess most extreme action that they could take would be to petition for a restoration of rights. That would dissolve, it would have to be heard by the court, and the court would have to agree, but that would be the avenue for just completely dissolving the guardianship and restoring their rights 100%. If it is a situation where someone's being exploited and maybe they do need a guardian advocate, but they need a guardian advocate that is acting in their best interest, then I think that the best place to start would be going back to the attorney that represented them initially, and see if that attorney could help petition the court to have a guardian terminated from their position. But if it is just a situation where someone is not getting a nominal amount of money that they want, the guardian is going to have the kind of the trump card to say, well, I think it's in your best interest that this is saved, or that this goes towards this expense and not video games, or whatever it may be. So I think the answer to that question is going to be on a case by case basis. What exactly is going on? Is it a serious problem where we have criminal activity, or is it has their capacity been restored and maybe now the guardianship is no longer appropriate? There's different avenues available depending on the situation.
So I know that there was one other question that was specifically about some of the costs and fees related to matters, and I actually think this is a multi-level question that could be developed from it, which is, this question was asking if there were any cases of pro bono work being done in order for guardian advocacy to be established. And then the other side of it is that even if let's say a parent is able to afford to buy the package that might be set up, whatever that process may be, to cover expenses for themselves in the case, but maybe they don't have the funding to pay for a second attorney for the person with a disability, or vice versa. the person with a disability, maybe the estate that that person has or whatever might be coming through would be able to help pay for their attorney fees to cover them in the guardian matter, but not the parent or not the other advocate that might be there. How are those fees covered, or is there a way to cover them when somebody doesn't have their own means?
Okay, so I'll start with the pro bono question, and my office is not doing pro bono work at this time, but if anyone is in need of pro bono services, they can still send me an email and I would be glad to point them in the direction of, I believe we have 2 different legal services organizations in town. One just went through a name change because it was too close to the name of the other. I don't remember either of them off the top of my head, but I would certainly be glad to locate that contact information and forward it. I'm not 100% certain that they do guardian advocacy cases, but I would certainly recommend starting there on that. As far as the expenses, I charge a flat fee, and I do like to discuss that with families individually. So I don't want to quote a fee now, but I will tell you that the filing fee with the court ranges from $235 to $400 to file the case with the court. And then the fee for the attorney that represents the disabled person. Most of the people that are on that court appointed list that I mentioned in Escambia and Santa Rosa County, it's just been kind of standard practice among the guardianship attorneys in our area that $500 is the fee for that lawyer. But I do believe there is an option when the person is indigent, that you may be able to file a form with the clerk to have that specific fee waived. Now, I am not aware of being able to have all of the lawyer fees waived, but I do think there is a form where you can have the fee for the attorney that would represent the disabled person waived if the disabled person is indigent, which most times they are. I haven't done that. Most of the clients that I work with are in the fortunate position that they can handle it themselves, but I would be glad to help anyone find that resource if they needed to. But I will say, in some of the other counties that I've worked in, they have a different system. Some of the counties in South Florida, the attorney for the disabled person is always appointed from the equivalent of a legal services. And so there's no fee ever in those counties. Why we do it differently here, I'm not sure. But we do the best that we can, I guess you could say.
Right. And
Okay.
I'm sorry, I was just gonna ask one more thing related to the fees portion, and that there are sometimes individuals may think that they can manage to do all the reporting and such, and so when the time for that reporting is due, and there may be fees if they had to use an attorney to continue to assist them with that. Is there places for them to get assistance with that as well?
I believe the reports have to be filed by an attorney. The statute says that a guardian has to be represented. Florida, I can't talk now. Florida probate rules say that a guardian has to be represented by an attorney. I don't have a problem quoting my fee. So for when someone hires me to do guardian advocacy, the fee that I charge them is from beginning through approval of the initial reports. And then for the annual reports, I just charge $250 a year. So it's not a lot to maintain the reporting requirements.
Mm-hmm. Those are some things that were all related to fees. And Joanne, you have some other questions there, so please go ahead.
I have a question about how the question says, how is this type of guardian advocate different from the guardian advocate in the Baker Act?
Okay. I think that the term guardian advocate, at least as far as I'm familiar, is specific to guardian advocacy. That being said, I am not super familiar with the Baker Act, but what I understand of the Baker Act is like a legal hold on someone for up to 72 hours when they are determined to be a danger to themselves or others. So I think the Baker Act is very different from the guardian advocacy and is a temporary situation to maybe stabilize someone who's in crisis. whereas the guardian advocacy is a long-term, if not permanent, tool. I hope that answers that question.
And I think that answers certainly some of it, and somebody's guardian advocate could change for different times that somebody may be Baker acted as well. They may have somebody that could be appointed, or somebody different is now the person who's care attending on most case days or things like that. That could change a little bit with the Baker Act. But at the same time, if a guardian is tired or not wanting to be the guardian anymore, then do they have to pay a fee again to be dissolved of their guardianship, or dissolved of their guardian advocacy? Or do they have, if that original plan was done like you had mentioned, where somebody might have already had their shared advocacy, where the backup plan was already titled, at that point where it was titled and that person becomes the advocate, at that point, then is that person then paying fees in order to have it become formalized?
Most often, yes, which is something that is to be considered when you're deciding, do I want to name this person as a standby guardian advocate, or do I want to go ahead and have them named as a co-guardian advocate now? Because if you name them as a co-guardian advocate now, even though you know and they know they're going to have a very hands-off approach until they're needed, that gives them the powers now so that when they are needed, there aren't additional costs. And the reason that there would be additional costs is because the lawyer is going to have to reopen the file and draft additional documents, potentially have another hearing if the judge wants to have a hearing. If it's someone new that has not been previously named as standby, there would definitely be another hearing. If it was a standby guardian advocate, I think you can avoid the hearing depending on the judge.
Thank you.
Mm-hmm.
Our next question is, when the court appoints a lawyer for an individual, do we pay for that lawyer?
That's kind of what you were sharing before.
So
Right.
I think it's case specific. Most of my clients that I work with, it's the $500. That's what, and when I work with clients, I do collect that up front, because that way, the day I get the order appointing that attorney, I write a check that day to that attorney, and that gets them motivated to meet with the person sooner, because they've been paid, they're on the books, and the sooner they meet with the person with a disability, the sooner I can get the hearing set, we can get the case moving forward. So that's why I collect it up front.
And our last question that we have in our box is, it says, from the date the court is petitioned, approximately how long does it take before the letter of guardianship is approved?
Okay, so that's a good question, and it's variable because it depends on how fast the pieces of the puzzle happen. So once someone retains me, I usually ask for a week to get my file open and get the paperwork drafted. If I need to get consents from anyone else, it could take a couple days, or worst case scenario, a couple weeks to get those consents back. I don't file until I have all the paperwork back. Then the next hurdle is to get that meeting scheduled with the lawyer who's going to be appointed. So that usually takes a couple weeks. Then we can get the hearing set. But I would say from beginning to letters, I would say from maybe 2 to 3 months. Don't quote me on that, but I think that's reasonable. Sometimes faster, sometimes slower. And then once it also depends on the judge's calendar. We have one of the judges on the probate bench right now also has a criminal docket. And so if I am requesting a hearing in a week where she has criminal trials, then half of her schedule that month is going to criminal cases. So I could be booking a hearing out a month and a half. Sometimes I call and they have a hearing in 2 weeks, and sometimes it's a month and a half. So it really just depends, but certainly less than 6 months.
Mm-hmm. And so there's just another question related to the time frames, and we know that we look at the age of 18. If a person was older than 18, but still not a person that would be perhaps much older with probate court and losing abilities, but if somebody was older than 18, would they follow the same process to come and contact you to have them placed on the guardian advocacy docket?
Yes, ma'am. It's the same procedure regardless of age. And I had one recently with a young lady who was in her 30s, and they just had not been aware of this tool until later in her life, and found out about it and thought, hey, that would be really helpful for us. And so they called my office. So you can definitely be over 18. The process is the same.
I have an additional question. If the child is a minor and the parent is not fit to be a guardian for the child that has a developmental disability, how would a grandparent go about becoming the guardian advocate?
That's a great question. And I just worked with a family on a case like this. And unfortunately, it's not a super simple process, because my answer is that you need sort of two guardianships. So right now, while the child is a minor, you would do a minor guardianship. And that is, you would mention the disability in it, but the disability is not the reason for the guardianship. The reason for the guardianship is there's a child that needs a legal guardian, and the natural parent is not able to fulfill that role. When the minor approaches their 18th birthday, you can petition within the already existing minor guardianship to transfer it to a guardian advocacy. So you would keep the same case number, same judge, everything would live in the same case file, but the nature of the guardianship would change at that point, because once they turned 18, the minor guardianship goes away, then the guardian advocacy becomes relevant. But I would say too, I have only done minor guardianships in a case, and it's been two cases, and cases like that where the parent is on board. If you're dealing with a situation where the parent's not on board, you may consider also talking with a family law attorney, because that may be more of a custody issue. And if mom and dad are not in agreement, then you may have to seek to terminate parental rights. So guardianship is an excellent tool when the parents can get to a place where they can say, you're right, I really need help. I need to go take some time and get this sorted out. And I would like you to care for my child until I'm able to step back in. Then guardianship's appropriate. When everybody's not on board, family law court may be a better avenue to make sure things are sorted out the right way.
And I think there could be another question that's related to that last one as well, which is obviously each case has its own individual needs, but many of our families in our communities here in our part of the state are not very well off. And sometimes there are cases where there are multiple family members in one family that might need a guardian advocacy as an example. And so certainly the children will be of different ages. So that's already an area where now if it's like you just said, for minors, they both might be minors today, but they both won't be minors when it transfers up to being an adult. Or, the case of school reports, they might currently today be in the same schools to get those reports, or at the same doctor's office to get the medical reports. But does the fee just automatically double or triple or whatever by the number of kids that are involved, or the number of potential transitions from minor to adulthood?
That's going to depend on the attorney. Every attorney will have their own policy. When I have done families with more than one child, I do have a discounted rate. There are two separate if there's two children, so there's two separate filing fees. There's two separate lawyers to be appointed if it's a guardian advocacy, but a lot of the paperwork and the legwork is the same, kind of mirror images. I mean, each individual is their own person, so their petitions are going to be specific to them. But because some of the work is duplicative, I do reduce my rate on those.
Okay, great. Well, I think that's all very good information, and I think that there's so much more that people can learn about pursuing guardian advocacy. And we appreciate this whole overview that you have given us today and this opportunity that Lauren Merritt's law firm has provided us. And we hope that individuals will be able to pursue this matter as needed. As always, Centers for Independent Living always look for the way that individuals can live their lives as independently as possible. So there might be ways that you can provide supports to your loved one who may not need to have a guardian advocate. But if the guardian advocate is the proper role and that you have decided that you want to pursue and that you have the disability and the information to support that can be followed through with Lauren in her office in the court system, then that is going, and that's in the best interests of the individual. Then of course the center is always wanting to support what is in the best interests of the individual. And again, you can reach Lauren's office at 850-741-2999, or you can reach the CIL's office at 850-595-5566. And we'd be happy to provide information and referrals to all appropriate parties. So whether you needed a different attorney to be referred to than than coming to Lauren because of the matters of a contested issue or the matters because of a fee matter, then those pieces could be conducted with Lauren. And then if there's any issue, any information referral, any skills building, any advocacy, peer support, youth transition or diversion that is related to disability that we can be providing you assistance with, the center is happy to do that. So I thank Joanne for being our tech host today. And I thank Lauren for being our featured keynote speaker on guardian advocacy. And again, I'm Carolyn Growie with the Center for Independent Living, and we're happy and proud to work with all of you in the community. Thank you.
Thank you, everyone. Have a nice night.